And Ms. Zenda, if you could.
Good afternoon, Your Honor. Allie Zenda on behalf of the people. Your Honor, the people would waive any potential conflict between this honorable court and the Office of the Public Defender. While the people believe there is no such conflict, people make this waiver an avoidance of all doubt.
All right, Ms. Pate.
Good afternoon, Your Honor. Assistant Public Defender Natalie Pate with and on behalf of the Public Defender's Office. Likewise, Your Honor, our office does not believe a conflict exists between this honorable court and our office, but if one were to arise, we would waive such a conflict.
Court for its part also does not believe there's a conflict either under the Michigan court rules or the cases decided there under. To the extent a conflict does exist, given the waivers, the court will consent to hear the matters. Okay. Court does call the case of the people versus Deario Felen.
Allie Zenda on behalf of the people, Your Honor.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Farrell, who stands to my right. Please state your name for the record, sir.
Deario Felen. Thank you.
Thank you, Your Honor. As to the case, we respectfully request to set it for final settlement conference and then to address bond when appropriate.
Jury final settlement conference will be June 6, 2025, 9 a.m. Jury selection, if necessary, June 9th, 2025, 8:30. Both of those proceedings are in person. Esteban.
Thank you, Your Honor. It is my understanding that Mr. Farrell's bond is currently denied due to an alleged bond violation and then his subsequent failure to turn himself in on that warrant as ordered by the court back in 2023, I believe was the year. As to the bond violation, he does admit to that and is asking the court to consider releasing him pending his final settlement conference. He does state that he did leave the state of Michigan, where he was originally from, to go to Georgia during one of the prior bond violations. He has provided me with an updated address in Ypsilanti, Michigan, where he currently stays with a family friend. The complaining witness does not reside there. He is willing to go on tether or comply with any other terms as ordered by the court. He's asking for release today on a PR bond. My client states to me that he came into custody on the warrant during a traffic stop for lights, and to my understanding, no new charges stemmed from that police activity. To my understanding, his only current Washtenaw County matter is a license case. We do acknowledge that there is a hold out of Livonia, however. He does also have a potential job that he is currently in the onboarding process for in Wixom at Purin doing assembly of car exhausts. He does have a 4-year-old daughter, and he is now local to court. We are asking the court to consider his release pending the final settlement conference.
But he was. It was almost 2 years.
Yes, Your Honor.
Good. Response.
I would object to any modification of bond. First, he failed to appear back in April of 2023. At the time of that, there was a couple bond concerns in which he had gone to Georgia without permission, violating his bond. And the victim had also informed us he'd been contacting her since his release from jail. That didn't get a chance to get addressed because he failed to appear back in 2023. I also have concerns as to this case that our office is going to be looking into is why it wasn't charged as a felony strangulation given the facts in the police report. And I just have concerns that he failed to appear back in 2023 and had to be picked up for this case to come back around. So I would object to any modification of bond at this time.
Anything else?
Just very briefly, Your Honor, the only thing I would state as to that is that Mr. Farrell came back to the Michigan area last month, he states to me. One of his reasons was he wanted to take care of this matter. That being said, he was picked up on a traffic stop. And I would just ask that he be released pending the final settlement conference or final settlement.
It doesn't necessarily make any sense. If he came back to take care of it, he could have turned himself in at any given point. He didn't do so. He had to be picked up.
I understand, Your Honor.
2 years later. Motion for bond reduction is denied. Bond will continue as denied.
Thank you, Your Honor.
Thank you so much.
In testimony's heat, fear speaks louder than memory gaps. Defense demands clarity. Prosecution leans on photos. Judge finds probable cause. Justice is set in motion, waiting beyond today's ruling.
Court does call the case, People versus Stephen Watson.
Alexis, on behalf of the people, Your Honor.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Watson, who is approaching. Please state your name for the record, sir.
Stephen Watson.
Thank you, Your Honor. As to the case itself, we asked to set this for final settlement conference and then address bond when appropriate.
Go ahead.
Thank you, Your Honor. So I know Mr. Watson was last in front of Your Honor for a PCC, or it might have been a preliminary examination, my apologies. And Your Honor said he may consider a bond reduction if there was a plan in place as to treatment. I did reach out to the CCOP program and emailed back and forth a little bit with Mr. Brown. And he states to me that in order to be assessed, they would need either a court order for referral. So my first request is if the court would consider signing an order for him to be assessed for the CCOP outpatient program in order to continue treatment, if the court would consider signing such an order.
I don't have a problem doing it.
Thank you, Your Honor. And I did state to Mr. Watson that it would be unlikely that he would be released prior to that assessment, but I would like to make a brief argument for that if the court would allow. So, Your Honor, I have spoken directly with Mr. Watson's mother last week. She does state to me that she really would like her son to be out. She actually currently resides in Detroit and has been involved in a building fire and then has a foot injury. All that being said, she told me that Mr. Watson is there at least once every other week, visiting her, helping her with her medical needs, and is hoping that he can be released and goes home. My client, however, also resides in Ypsilanti, away from the complaining witness. He had full-time work and he has spoken to a supervisor since his time in incarceration, but if he is here too much longer in jail, he may lose that employment. He's willing to do a tether, and he has also states to me he is willing to test every single day. I do understand the court may be wanting to wait for that CCOP assessment. However, I would be asking if the court would consider his release pending the assessment as well as the final settlement conference. He does have a lot of family support. I do not believe Mr. Watson would be a flight risk or a danger to the community, and I would ask that he be released today as well, pending that assessment.
All right, I don't need a response. I'm not going to do that. I think with Mr. Watson, he was quite frankly frank with me in terms of what was needed previously. And until I see that assessment, I'm not going to change anything on that.
Understood, Your Honor. Thank you. And I will provide that order to the court today.
Well, I'm going to order him to CCOP outpatient program.
Understood, Your Honor.
Will they do the assessment on that order? Did they need something?
Yes, they will do the assessment on that order, to my understanding.
And I've signed it.
Oh, perfect.
I'll speed this along.
Thank you so much.
Assessment, see where he is, and then if it needs to be brought back before the court, contact Ms. Wyatt. We can try to figure out how we can get that done.
Absolutely. Thank you, Your Honor.
Appreciate it.
Oh, the dates, his jury final settlement conference, June 6th at 9 a.m. Jury selection if necessary, June 9th, 2025, 8:30.
Thank you, Your Honor.
Okay. All right, thank you. Court stands in recess.
Voices rise. Arguments clash. She recalls choking. Defense doubts her clarity. Prosecution insists Marks tell the story. Judge agrees there's cause. A trial awaits where silence and truth collide.
We're good. Court does call the case, People versus Deontay Arnold.
Alexis, on behalf of the people, Your Honor.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Arnold, who is present via Zoom. Sir, can you please unmute and state your name for the court?
Deontay Arnold.
Thank you, Your Honor. I have discussed this matter with my client as well as briefly with the people. At this time, we wish to set the case for final settlement conference.
Jury final settlement conference will be set June 6, 2025 at 9 a.m. Jury selection, if necessary, June 9th, 2025 at 8:30. Both of those proceedings are in person. Bond will continue. Thank you, sir.
All right, thank you.
Thank you, Mr. Arnold.
You're welcome. Thank you.
Court calls case People versus Alexis Barry.
Natalie's been on behalf of the people, Your Honor.
Assistant Public Defender Natalie Pate with and on behalf of Alexis Barry, who is present via Zoom. Can you please unmute and state your name for the record?
Alexis Barry.
What are we doing?
Thank you, Your Honor. There is a resolution in this matter in which my client will be pleading no contest as charged under 4A.
And that's correct, Your Honor.
Can you please raise your right hand, please? Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
State your name for the record.
Alexis Barry.
All right. It is this court's understanding that you're going to be pleading no contest to the charge of domestic violence. That's a misdemeanor, punishable by up to 93 days in jail, $500 fine plus court costs. Do you understand that?
Yes.
Do you understand what a no contest plea is?
Yes.
All right, two things about it I have to make sure that you understand. The first thing is that it first of all means that you're no longer desirous of contesting this matter. You understand that?
Yes.
The other thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes, Your Honor.
All right. Basis for the no contest plea.
Potential civil liability, Your Honor.
All right. So to that charge, how do you plead?
No contest.
Now you understand that by pleading no contest, you'll not have a trial of any kind.
Correct.
You signed an advice of rights form?
Yes, Your Honor.
Any question regarding any of those rights?
No, Your Honor.
All right, under paragraph 5, those are your rights. If you're part of a trial, you understand that you're giving up those rights as well as all the rights contained on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today to get you to plead no contest to this charge?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily
Yes, Your Honor.
and of your own free will.
Yes, Your Honor.
Court has been provided and has reviewed Pittsfield Township Department of Public Safety report for their case number 25-7005. Any objections to the court having reviewed that report?
None from the people, Your Honor.
No, Your Honor.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Counsel, have I complied with the court rule?
Yes, Your Honor.
Yes, Your Honor.
Court will accept the defendant's plea of no contest to this charge. Defendant is referred to probation for a pre-sentence investigation and report. Sentencing in this matter will be June 16, 2025, 1 p.m. Bond with its conditions will continue. Ms. Mary, I need you to wait on the line. We're going to put you into a breakout room with our probation department so we get this process started, okay?
Okay.
All right, thank you.
Thank you. Thank you, Your Honor.
Court does call the case. People versus Nicholas, is it Bastanek?
Natalie's been on behalf of the matter.
Your Honor, there's actually no counsel on this. Nothing was ever signed and.
Yes, sir. State your name, please. Oh, it's gone.
Conflicting stories unfold. She insists on her truth. Defense points to missing details. Scratches captured in photos bolster her claim. Judge rules trial must continue. The fight for justice begins.
Mr. Bosanek, can you unmute?
There we go. Yep.
Okay. All right. State your
Sorry
name,
about that.
please, sir. No, not a
Nicholas
problem.
Michael Basa-
Okay. I don't have an attorney on this case. You were arraigned back in 2003. I think I was 2 years old. No, I'm kidding. All right. You were arraigned back in 2003 on this charge. Do you recall being arraigned on this charge, sir?
Not at all, Your Honor.
Okay. Then let me just at least, oh, go ahead.
Per my notes that we had, he, in the previous case, it was at least represented to our office that he was representing himself.
Oh, okay.
That was a note from 10/14/2003.
Oh, that the defendant was going to represent himself.
Correct.
Do you remember doing that, sir?
Not at all.
Okay. All right.
Yeah.
Let's do it this way so that we can at least. All right. Sir, the complaint in this case alleges that on or about June 24th, 2003, at the location of 2220 Glencoe Hills Drive, number 11 in Pittsfield Township, Washtenaw County, state of Michigan, that on that date and at that location that you did make an assault or an assault and battery upon a Katie Stiver, and that you
Yes,
had a
apparently
dating
that
relation.
was it.
Hang on. I don't want you to say anything about it. I'm just trying to let you know what the charges are. Okay, sir? All right. And that you had a dating relationship with that person. That's commonly known as domestic violence. That's a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. Count 2 alleges on that same date and at that same location that you did commit the offense of malicious destruction of personal property, $200 or more, but less than $1,000, in that you maliciously destroyed or damaged an automobile belonging to Katie Stiver. That's a misdemeanor punishable by up to 1 year incarceration, $2,000 fine plus court costs. The fine could be increased if 3 times the value of the property, or the injury to the value of the property. If that's greater than $2,000, that becomes the maximum fine. You understand all of that, sir? Do you understand that, sir? I'm not asking you whether you did it or not. Do you understand what the charges are?
Yes, this was the first time I've actually heard all the charges. Yes.
Oh, okay. All right. So back on September 22nd of 2023, it indicates that you stood mute to those charges, and the court entered a not guilty plea to that. Counsel was not assigned at that time. The prosecutor's notes are indicating that you said you were going to represent yourself. However, sir, at this time, do you wish to be represented by an attorney?
No.
You sure?
Miss Stivers has contacted the prosecutors and wanted
Hold
all
on,
charges
hold on,
of anything
hold on.
dropped.
Hold on, sir. All right. It's not going to matter, at least at this point, what she might say, because you've got this case pending. Okay. So I don't want you saying much about the case itself or contact or anything along those lines, because just so that you know, as part of your bond conditions, you weren't supposed to have any contact with Miss Stiver. Okay. So I'm only saying that, sir, because I don't want you to say anything that potentially can have an effect on you, if you follow what I'm getting at.
Of
All
course.
right. So I'll go back to my question. You want to be represented by counsel?
No.
You sure?
Yeah.
Okay. Then what do you want to do with this case next, sir?
What do I need to sit there and do?
Well, the next thing that would happen is I would set it for trial.
Okay.
You want a jury? What? You live in New Zealand?
I live in New Zealand. This is from
Okay.
22, almost 23 years ago.
All right. Okay. So, sir, listen. I'm either going to require that you come back for a trial, or we can try to find a way to resolve this without you having to try to fly halfway around the world to get back to us.
That'd be
Okay.
fantastic.
So in order to do that, I'm going to suggest to you, I can't force you to do it, that you take an attorney in this case. I would appoint that person to just represent you in this matter.
That sounds
And
great.
that way
Let's
the
do that.
conversations can be had, and hopefully this 20 some odd plus years thing can be
I
resolved.
never even knew I had this.
So
Yeah.
now, hold on, hold on. Hold on. I'm gonna ask you again, sir. Do you wish to be represented by an attorney?
Yes, please, sir.
Yay! This is a public defender case.
I like it.
He's a good Kiwi. Don't worry about it. We'll be all right.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Bosnack, we would waive any further reading, stand mute, and ask for an adjourned pretrial date,
All right.
please.
I will adjourn the pretrial in this matter. I'll adjourn it to
June 2nd.
June 2nd, 2025, 1 p.m.
Yes, sir.
1 p.m.
1 p.m.
Okay. And yes, you can appear via Zoom again. Okay.
Thank you very much.
And did you need